Thank you, Your Honor.
What was the last case we had? Was that a foreclosure as well? I don't even remember.
Divorce,
Was it a divorce? Yeah, it was a divorce.
and then an insurance case before then.
Yeah.
I'm not following you around, I promise.
Yeah. You're stalking me. All right.
May it please the Court, Timothy Weber here on behalf of the appellant, J.H. Home Mortgage. The issue in this case is that the trial court entered a final judgment of foreclosure in favor of a party who showed no rights whatsoever in the documents that were at issue. In fact, the only evidence in this case was a promissory note made payable to SunTrust Mortgage, Inc., with an endorsement on it in blank that was voided, and which the appellee stipulated at trial that they were not relying in any way whatsoever on an endorsement of the note. So that calls into question how the trial court entered a final judgment in favor of Fannie Mae in this case, when in fact the only evidence was a promissory note payable to SunTrust Mortgage, Inc. with no endorsement, and then Fannie Mae produced at trial the only record cite in their brief as to their standing, a screenshot that suggests from their business records that they acquired this loan in 2007.
Like by an assignment or something?
There's no evidence of an assignment. There's no evidence of any written document assigning the loan to Fannie Mae. There's no endorsement.
Certainly the initial filing of the complaint by SunTrust would contradict the notion that Fannie Mae had standing at the inception.
It's even worse than that. So SunTrust Mortgage files suit alleging that they're the holder, and then they file the note of record. In their brief, the appellee claims, we're a successor plaintiff. We somehow took by assignment during the litigation, yet they produced no assignment and no evidence they ever possessed the note. And the UCC is very clear, in order to negotiate a promissory note, there has to be a transfer. And they cannot identify any of the three provisions in 673-3011 entitling them to enforce the instrument in this case. And the absence of endorsement is the key element. They cite the Taylor versus Deutsche Bank case as their argument for standing. There was a written assignment of the note, and we don't have that here. We have a screenshot suggesting an acquisition of this note in 2007 that was not even Soteris's business records. The Soteris witness says, oh, well, Fannie Mae allows us to show this screenshot. So this was Fannie Mae's records that Soteris is allowed to show.
Screenshot of an entry on
It's a screenshot that just says date of acquisition 2007. Yet SunTrust, when they originally filed the suit, there's a corporate assignment of mortgage in 2011 from MERS to SunTrust Mortgage attached with the initial complaint. And so the contradictory information that was presented in this case, I think, is fatal to the judgment. And the fact of the matter is that the only pled theory from Fannie Mae in the Second Amendment complaint is not that they were the owner, but that they were the holder. They specifically allege in their complaint, plaintiff is the holder of the note. They assert in the complaint that they are attaching a certificate of their possession, yet that was not attached. One had previously been filed in the case by SunTrust, certifying continuous possession from the date of delivery by the borrower to the date they filed it in the trial court before Fannie Mae's appearance. And so the same parties who verified this continuous possession of the note by SunTrust, the same lawyers, without leave of court, based solely on an order dismissing SunTrust's complaint with leave to amend, file a Second Amendment complaint on behalf of an entirely new party that's verified, and it directly contradicts the certification they just filed in the trial court, alleging in their Second Amendment complaint that somehow Fannie Mae is now a holder of this note. And so a verified Second Amendment complaint claiming Fannie Mae was the holder right after the same lawyers had filed a certification of continuous possession of the note by SunTrust Mortgage until it was filed with the court. So then we have in the answer brief, SunTrust must have been an agent for Fannie Mae. The problem is that agency theory only works if Fannie Mae ever became a person entitled to enforce the instrument. And they never did, and this record shows they never did, precisely because there was never an endorsement, there was never a delivery, there was never a written assignment, and there was never any documentation showing a transfer to Fannie Mae. And so what we have here is a situation where a party has completely failed to make proof of their basis for entitlement to judgment. I did sit here for a little bit of the discussion earlier on Colson. I would point out that at the beginning of this trial, the defendant raised the complete inability of SunTrust to proceed with these, or as Fannie Mae to proceed with these inconsistent facts, and asked for dismissal at the beginning of the trial. Granted, there's no specific I move for involuntary dismissal under 1.420 at the close of the evidence, but there is a specific request at the beginning of the trial saying that the conflicts are irreconcilable on this issue of standing and the case should be dismissed at that point. And those were essentially admitted facts at that point in time at the beginning of the trial that resulted in the fundamental defects in the case. In addition, of course, the request was made to dismiss the Second Amendment complaint for failure to state a cause of action precisely because of the lender's failure to attach any document showing any interest in the mortgage, alleging any facts showing any interest in the note or mortgage, other than the allegation that the plaintiff, Fannie Mae, was the holder of this note, and attaching a note with an endorsement stamped void. So we don't have a blank endorsement here, and we don't have a basis for proceeding. We have raised additionally that even if they were somehow able to overcome that hurdle, we have this issue of the hearsay associated with the prior servicer's records. I think one of the problems why we have a failure to meet Callaway or WAMCO or any of those decisions in this case is the complete lack of trustworthiness that's involved. Here we have a gentleman who says, I was first hired in October of 2013 by Ceteris to service loans for Fannie Mae. In that same month he was hired, supposedly there's a service transfer from SunTrust Mortgage to Ceteris. But he admitted on cross he had no knowledge how SunTrust, where, when they kept their records, how they did anything, that we're relying solely on the information SunTrust told us as to what the loan balance was when we started keeping our records. I would submit without any predicate as to the reliability of the underlying records, the mere statement that someone else told me this is what the balance is insufficient, and there's no detailed testimony concerning how that's checked for accuracy. But I think what's more fundamentally a problem here is we're talking about records that we want to say are inherently trustworthy because they're between banks and they're between sophisticated parties and so on and so forth, yet we've got a screenshot from Fannie Mae claiming they own it, and we've got assignments of the mortgage occurring in 2011. Everything in these records is inconsistent, and yet we're to deem them as trustworthy and look the other way solely because a gentleman who started work the same month this happened tells us that this is the number they gave us. I would submit to the court that on the hearsay issue, the court should likewise reverse, even if somehow they could come up with standing in this case. I would submit that this issue of standing is fundamental and requires a dismissal on remand, and unless the court has any further questions, I'll rest on our brief. Thank you.
Thank you, Mr. Weber. You have right at 10 minutes. No.
Good afternoon, Your Honors. My name is Elizabeth Frau, and I represent the appellee in this case, Federal National Mortgage Association, also commonly known as Fannie Mae. In this case, the trial court's decision is properly affirmed on appeal. Fannie Mae proved its standing, and that notice was sent as a condition precedent to foreclosure at a non-jury trial in this case. Where competent substantial evidence supports the trial court's decision below, the order is properly affirmed on appeal. In his argument, the appellant alleges that SunTrust did not sufficiently prove standing at inception, or that Fannie Mae proved standing at the conclusion of the case prior to judgment being entered. And notably, in this case, SunTrust Mortgage is the original lender in this case. They filed the original note with the court in this case, and they filed the original complaint with the court in this case. Subsequent to SunTrust, the amended complaint in April being dismissed by order of the court, Fannie Mae was substituted in as the plaintiff in this case. Throughout, Fannie Mae did not just come out of the clear blue. Throughout this case, SunTrust alleged that it was the holder of the original note and that Fannie Mae was the owner. And the distinction there is important because simply because you are the owner, it is not synonymous with the term holder under 673.3011 Florida statute. And that distinction has become more discussed readily in the appellate case law that's come out of the 4th DCA. There is a case, Wells Fargo versus Morecom, where the court specifically states that you do not have to be an owner and a holder. So in this particular case, while appellant will have you believe that there is a conflict in the evidence, there's actually no conflict in the evidence, I would submit to this court. Essentially, SunTrust was the original lender. They filed the original complaint. They alleged they were the holder. In other words, they held the original note on behalf of Fannie Mae. They surrendered that note to the trial court. The trial court did not accept that pleading and dismissed their complaint. This was litigated and disputed at a motion to dismiss hearing before the trial court. The complaint was amended. Eventually, it was amended twice, and the final amendment, the second amended complaint on which this case traveled, was amended after amendment to Florida Rule of Civil Procedure 1.110 subsection B. And as this court may be aware, foreclosure law has morphed over the years, and there are more stringent pleading requirements. And in order to meet those pleading requirements, the appellee, Fannie Mae in this case, was granted 90 days to amend its complaint, and it did so. And that second amended complaint, which is the operative pleading in this case, states that Fannie Mae is the owner of the note, and at that point, the loan had already transferred to Ceteris as the servicer. The holder of the note, SunTrust, had already surrendered the note to the court. At that point, possession of the note is impossible. And as a successor plaintiff, Fannie Mae is entitled to rely on that previous possession of the prior plaintiff in this case to become a successive holder of the note.
Okay, SunTrust is the original lender.
Correct.
How did Fannie Mae become the owner?
They purchased it, and that is that screenshot he referenced before.
So that's a picture of a computer record that says on this record
October
says on that
2007.
date there was an assignment.
Correct, Your Honor. Fannie Mae purchased the underlying debt, in essence. So they are the owner. They are the beneficiary of the... And this is a record, this is part of Ceteris' business records. It's a record that's regularly maintained as...
That it obtained from SunTrust?
That they had obtained from SunTrust and from Fannie Mae. It's a Fannie Mae screenshot specifically, but it's taken from the SunTrust platform.
So there's no even picture of the assignment itself?
There's not going to be an assignment of the note. The note is going to be endorsed, and in this particular case, we agree SunTrust endorsed the note in blank and then voided that endorsement.
Right, so
essentially,
there's no endorsement.
There is an endorsement that is voided.
Right, so there's no endorsement for purposes
There's
of
no
this case.
legal operative endorsement, but the
Okay.
fact that there is an endorsement and that SunTrust maintained possession of that note and later filed it with the court in its original possession is an important fact in this case that the trial court did
Yeah, but
consider.
you have to document Fannie Mae now having the ownership or the right essentially to...
Correct, and even from the very beginning,
And
SunTrust
the only thing
pled.
you've got is a screenshot
We have the
a
testimony,
computer
we have the
record.
testimony of the loan servicer, Ceteris.
who
says-
said he went to work that month and this happened long
He
before
had-
he ever
he-
got
he-
there.
Now
And
he,
this was done by SunTrust.
now he is a corporate representative of business. A business is not required to have personal knowledge. It would be impossible to bring somebody with personal knowledge of all of these events, especially in a mortgage foreclosure setting. But in this case, Mr. Romero was the witness for Ceteris. He explained that Soteris, as part of its regular business practice, has a boarding process when it receives loans serviced by a prior loan. I mean, the testimony in this case is extensive with regard to that boarding process. It spans several pages. I wrote it down here from pages 33 through 40 of the transcript in this case. He discusses a 15-day process, a two-part audit system for checks and balances to assure that all of the information that's being boarded and accepted onto the Soteris platform is accurate. If there's any discrepancies, they return to the prior servicer and request additional documentation or proof that that information is correct and how they arrived at that information. And so after this...
So the thing that comes over is a picture of a computer record of an assignment?
Not just a picture of a computer assignment. In this case, there's also a limited power of attorney between the servicers, which would be SunTrust.
No, that's between the servicers. I'm talking about between SunTrust and Fannie Mae.
Between SunTrust and Fannie Mae. Now, that limited power of attorney, there is a line in there that references the agreement between SunTrust and Fannie Mae to service the loans in this case, and it references by date the specific agreement.
Where's the assignment of the ownership of the loan?
There's not going to be an assignment of the note. In this case, there is an assignment of the mortgage, which predates the complaint from MERS, Mortgage Electronic Registration Systems, to SunTrust Mortgage, Inc. But again, there's not going to be an assignment of the note. The note is going to be, the note is essentially a check payable to the bearer or payable on demand to the person that is the person in possession.
How did Fannie Mae get involved in this?
They purchased the underlying debt. They purchased it from SunTrust.
Your assertion that that's the case, the evidentiary basis for that
Correct.
is a screenshot
And the
of a
testimony
computer.
of all of the parties in this
and a
case.
testimony of a servicer who had no personal knowledge of that.
That would be correct.
Okay.
That would be correct. The servicer does not have personal knowledge of this
Right.
information, other than that he did personally view this information. He verified the information on his computer data before he testified under oath before the court. SunTrust also filed numerous affidavits in this case at the time that they filed the initial complaint, asserting to the court that Fannie Mae was the owner. They at no point claimed to be the owner of this note or the underlying debt. The court at that time did not accept that change in position, that they owned it, but I hold it. And the law at that time was very unclear, and it's become more relevant now that is essentially under statute proper, that you can own a note and not be the holder, or you could not be the holder and still be entitled to enforce the note. Standing can be reached through many different vehicles, and there's a long progeny of cases now that are explaining the different various vehicles to which a party and a mortgage lender can prove standing in a foreclosure context. So there is evidence in this case of standing, and I would submit to this court the Colson case would be instrumental in its understanding and should not be brushed over. In there, the court, although they're speaking towards damages, the court says, the appellate court will reverse the award without remand for additional evidentiary hearings. Where the record includes some evidence supporting the fee and cost award, this court may remand for further proceedings. In other words, if you agree that there is a conflict in the evidence and that there is insufficient evidence of standing on behalf of Fannie Mae in this case, the proper disposition in this case would not be a dismissal, as argued by the appellant. The proper disposition where some evidence does prove that Fannie Mae is the owner and the holder by successor in this case, by being the successor plaintiff, that the case be remanded for further proceedings. I would submit to this court that that is not necessary at this point. There is no affirmative defense or evidence proving an affirmative defense that Fannie Mae lacked standing. And Fannie Mae did provide proof through testimony of a witness and through this screenshot, this documentary evidence, that it was the owner. It is corroborated or cumulative to the other evidence in this case, specifically SunTrust's pleadings filed with the court stating that Fannie Mae was the owner and that they were the servicer. The limited power of attorney stating that SunTrust assigned to Soteris pursuant to its agreement with Fannie Mae for the servicing of Fannie Mae loans, all rights, title, and interest to service and continue to litigate certain loans that are part of that limited power of attorney, including the loan in question. So when taken in view entirely, the case in a whole spectrum, there is evidence and sufficient evidence of standing in this case, I would submit to the court, and that dismissal would be an inappropriate result. The defendant also, or the appellant in this case, also took issue with the lack of trustworthiness with regard to Mr. Romero's testimony, and the Supreme Court of Shaw v. Shaw is on point here. It says the function of the trial court is to evaluate and weigh the testimony and evidence based upon its observation of the bearing, demeanor, and credibility of the witnesses appearing in this case. I would submit to this court that the trial court was in the best position to determine the trustworthiness of the evidence and the documentary and the witness's testimony in this case, and that is the prerogative of the trial court to decide, who hears, obviously, many of these cases throughout the day and throughout their work week, and that it is his function and his responsibility to determine trustworthiness and the credibility of a witness. There were no other witnesses to refute the trustworthiness of the records and the evidence presented in this case. There were no contradicting facts. There were no contradicting other evidence of any form or sort in this case to negate the information or the evidence that was submitted. In addition, I would remind this court that J.H. Home Mortgage Rescue is not the original borrowers under this loan. They are successors to the borrower by purchase of bare legal title that is subject to the mortgage in this case. And the documentary deed that they have that they allege an interest through specifically states that it's subject to the mortgage in this case. So they purchased the loan while it was in default. It was in bankruptcy at the time, and the owners surrendered their interest in the property itself to title, which is all they held at the time. And J.H. Home Mortgage Rescue purchased title to this property from the defaulted borrowers, knowing full well it was in default. During the course of this case and the years after, no mortgage payments have been made. There's no dispute as to the amount of damages. There's no dispute as to the payment history or the evidence that was actually introduced in this case. Their objection is, hey, don't let this evidence in. But there's no actual defense with regard to the evidence once it's in evidence. So there's no dispute as to, I made some payments, or you're incorrect here. In which case, if it would be essential, I would agree that there be additional evidence, or that SunTrust come to the table and explain certain, personally explain certain entries in that payment history, but that's just simply not the facts in this case. The loan was in default before the complaint was filed. It was in default before they purchased any interest in the property, and it's been in default throughout this entire time, and there's no dispute as to damages in this case whatsoever. There's no dispute as to the default in this case. The only disputes that we have heard here on appeal is to the bank's standing as the owner, which I submit to this court was proven with competent substantial evidence, and to the trustworthiness of the corporate representative who testified in this case, which I submit to the court is up to the trial court to determine the credibility and the trustworthiness. And the trial court clearly found the testimony and the evidence to be credible and believable, and thus entered final judgment in favor of the appellee. In conclusion, I would submit that competent substantial evidence in this case supports Fannie Mae's final judgment of foreclosure, and that this court should affirm the decision on appeal.
Thank you, Ms. Brown.
Thank you.
I'll be very brief. A promissory note is a negotiable instrument, and there are very specific ways in which a promissory note can be negotiated, none of which occurred in this case. The statute specifically provides if there's even a transfer of a promissory note without an endorsement, that the person does not, a negotiation does not occur until the endorsement is made. And here we have a situation where there never has been an endorsement, and Fannie Mae stipulated at trial that the endorsement attached to the complaint, clearly voided by SunTrust Mortgage, is not anything that they are going to in any way, shape, or form rely upon in this case. That was their quote at trial. And yet here we are hearing, well, there was an endorsement, but it was voided. I mean, further calls into question this screenshot from Fannie Mae suggesting that they own it when this endorsement was voided, and particularly in light of the fact that SunTrust took an assignment of the mortgage 4 years later. The fact of the matter is that in the absence of an allonge, an endorsement, or any document evidencing a transfer, there's simply no evidence here that there was negotiation or that Fannie Mae was a person entitled to enforce the instrument under the UCC. Thank you.
Thank you, Mr. Weber. Thank you all. We are finally adjourned.